Chapter 2, Compliance, Law, and Ethics. The Chapter 2 learning outcomes include differentiate between law and ethics, describe the ethical foundations and approaches that underlie modern codes of ethics, identify major national and international laws that relate to the practice of Infosec, and discuss current laws, regulations, and relevant professional organizations. We will cover these 4 learning outcomes in the following 5 sections. Section 1, Introduction to Compliance Computer Laws. In this section, we will be covering the 4th of the chapter learning outcomes. Discuss current laws, regulations, and relevant professional organizations. Most of you currently work in healthcare organizations and may already be an information security manager or may simply want to know more about information security management. Thus, it's important for you to explore the scope of the organization's legal and ethical responsibilities regarding securing information assets and develop strategies to minimize the risk of illegal or ethical oversight. To minimize potential legal and financial liability, Infosec professionals need to stay current with laws, rules, and regulations and keep updated on new laws and ethical issues as they become important. Information security managers are responsible to educate the organization's employees and managers about their legal and ethical obligations and the proper way to use technology. Then the employees within the organization are able to stay focused on strategic goals and not become distracted by ethical concerns or violations. First, let's look at why managers and those who use technology need to understand and be concerned about information and data security. If you look at the cyber threats and incidents that have occurred in the last few years, companies are seeing an increase in malware, phishing attacks, hacking, and spam. At the government level, we've seen attempts by foreign governments to influence the U.S. election systems. We also continue to see increases in cyber espionage, cyber warfare, and cyber terrorisms. These issues affect everyone in an organization and within a country. Your data is valuable and you don't want to inadvertently share or release that data. Bill Gates noted the importance and relevance of security as computer capabilities continue to increase. He theorized that people will be hesitant to use technology if security problems aren't addressed. I don't necessarily agree with him. We have become so attuned to data breaches and security lapses that they're not that important anymore. If data is released, well, the company will, after the breach, ensure that your data isn't further compromised through identity theft. Credit card companies will not charge you for purchases made due to the breach. Of course, those are only for the incidents that we know occurred, and experts do recommend that organizations only find and report about 10% of cyber attacks. Clearly, securing data and information within an organization is relevant to everyone within the organization. Those who understand, protect against, and respond to attacks on their information assets will be better positioned than those organizations that do not. As an information security professional, it's imperative to understand the legal framework within which an organizations operate. You don't need to be a lawyer, but you do need to be well versed in the law as it relates to securing the organization's information assets. The legal environment in which organizations function influences their behavior. More heavily regulated industries, like healthcare, will spend more time, money, and other resources to ensure compliance than other firms with less liability. Regardless of the industry, however, all managers must be aware of and adhere to the legal requirements for collecting, storing, and using information. When information is particularly private, sensitive, and personally identifiable, the obligation to secure the data is even higher, much like patient information in the healthcare field. There are many different types of laws and regulations that are relevant to the responsibilities of an information security professional. These laws include constitutional law, statutory law, regulatory or administrative law, and common law, cases, and precedents. Constitutional law, as the name suggests, derives its power from the U.S. Constitution or other local, state, or region's constitutions, or their international counterparts. As organizations continue to expand globally, international considerations must not be overlooked. As organizations expand, they should consider the advisability of hiring legal counsel with expertise in the field and in the particular city, county, state, region, or country within which the organization operates. Statutory law derives its power from a legislative branch specifically tasked with the creation and publication of laws and statutes. These legislatures could be local, state, regional, national, or international. Enforcement powers vary widely. Within statutory law, one can further divide laws into their association with individuals, groups, and the state, or any combination of these three categories. For instance, an individual can claim harm from a doctor, or a group of individuals can claim harm from the state's healthcare guidelines, etc. Within statutory law, civil law embodies a wide variety of laws pertaining to relationships between and among individuals and organizations. Civil law includes contract law, employment law, family law, and tort law. Tort law is a subset of civil law that allows individuals to seek redress in the event of personal, physical, or financial injury. Tort literally means harm. The harm may be physical or less tangible harms. For instance, if the publication of health records of a famous actress damages her career, she could sue the organization that did not protect her information assets. However, in tort law, harm must be shown. Criminal law addresses violations harmful to society and is actively enforced and prosecuted by the state. Criminal law addresses statutes associated with traffic law, public order, property damage, and personal damage. Infosec professionals must be familiar with all types of laws to be effective in securing the information assets of the organization. Seeking advice from legal counsel with expertise in the area is also recommended. You are not a lawyer, nor am I, and you need their help. Regulatory or administrative law comes from an executive branch or authorized regulatory agency. This type of law includes executive orders and regulations. Since the executive branch of government enforces the rules, executive orders may have the effect of law. Congress may then pass other laws that override the previous executive order, and or the judicial branch may decree that the order is unconstitutional. It's important to stay up to date with past, current, and projected future regulations that may affect your healthcare organizations. Common law, case law, and precedents derives its power from the judicial branch of government. Precedents are established through decisions made by judges in court cases. These precedents are then used as reference guides for future cases. The judicial branch refers to previous decisions when making future decisions, but they are not always followed 100%. Public and private law are important concepts to review as an information security professional. Public law regulates how government agencies are structured and managed and the agency relationship with citizens, employees, and other governments. Public law includes criminal, administrative, and constitutional components. In contrast, we have private law, which is a subset of civil law and helps to regulate relationships among and between individuals and organizations. Private law includes family, commercial, and labor components. Let's take a brief stroll down history lane, beginning with the mid-1980s. First, we need to recognize that the legislative branch is unable to keep up with the pace of technological change. So once a law is passed, it's almost immediately out of date with current technology capabilities. We start with the Computer Fraud and Abuse Act, which was passed in 1986. CFA is a cornerstone of many other computer-related federal laws and enforcement efforts. 10 years later, in 1996, CFA was amended by the National Information Infrastructure Protection Act. The amendment modified and updated some of the sections of CFA and increased penalties for lack of compliance. We move to 1 year after CFA, and the Computer Security Act was passed. This was one of the first attempts to protect federal computer systems in particular. CSA established minimum acceptable security practices for those who maintained and did business with the federal governments. CSA also set up a Computer Security and Privacy Advisory Board within the Department of Commerce. This was one of the first groups to specifically look at privacy concerns in a world with ubiquitous internet capabilities. CSA requires mandatory training in computer security awareness and computer security practice for all federal computer users. You can see that Infosec professionals need to keep pace with changing laws in order to meet legal requirements. Another component of CSA was charging National Institute of Standards and Technology, NIST or NIST, and the National Security Agency, or NSA, with development of several technology and InfoSec-related tasks, including developing standards, guidelines, methods, and techniques for managing, securing, maintaining, and updating computer systems. NIST updates and publishes cybersecurity guidelines regularly, seeking to maintain the security of the information assets in the U.S. and avoiding economic, public safety, or health issues if critical infrastructure components were to fail. Setting uniform standards and guidelines for federal computer systems. These guidelines are used to evaluate how to protect the information assets of organizations. Setting technical, management, physical, and administrative standards and guidelines for the cost-effective security and privacy of sensitive information assets in federal computer systems. Establishing guidelines for training for security and awareness for users with access to sensitive information assets. These guidelines can assist InfoSec professionals as they design security education, training, and awareness efforts within their own organizations. And specifying validation procedures for standards and guidelines and methods of evaluating the effectiveness of the standards through research and liaison across groups where possible. These guidelines may help assess the effectiveness of programs in place to protect organizational information assets. Clearly, these guidelines are important for information security managers. Now we move to one of the more contentious technology-related laws, the Patriot Act. It was hastily passed after 9/11 at a time when Americans felt vulnerable and wanted Congress to do something. Congress did do something. The Patriot Act modified the Computer Fraud and Abuse Act discussed previously and provided law enforcement agencies with more power to combat terrorism. Wider coordination among federal agencies was allowed, which conceivably would lead to better prediction of terrorist activities. In 2005, the Patriot Act was updated and extended, in many cases permanently enacted some of the portions of the Patriot Act that were due to sunset. It was reauthorized by Congress and signed by President Bush. In 2015, the Patriot Act was once again reviewed. While some portions were extended and others allowed to sunset, particular controversy surrounded Section 215, which allowed the NSA to collect and report on metadata. This is where NSA recorded phone conversations, the metadata, who it was to and from. As a result, responsibility for collecting and reporting on metadata was passed to the telecommunications industry from NSA. These updates were passed by Congress and signed by President Obama. To summarize, information security professionals have an inherent responsibility to be aware of and follow all rules and regulations of the industry, as well as all laws and other regulations passed by local, city, state, regional, national, and/or international bodies. Federal laws continue to emerge, but creation of laws is a cumbersome and time-consuming process and takes time. By the time a new law is passed, technology has typically already moved well beyond the provisions of the laws. State laws vary, and information security professionals must be aware of those differing laws, particularly for healthcare organizations that encompass multiple states. International laws only make the process more complex. Major computer laws emerged in the 1980s with passage of the Computer Fraud and Abuse Act and the Computer Security Act. In 2001, the broad, widely encompassing Patriot Act was passed, and it has been renewed several times since then, although portions of it have been allowed to sunset. Section 215, which dealt with NSA collection of metadata on telephone conversations, was changed, with responsibility for collection of the data shifting to telecommunications companies. We continue Chapter 2, Compliance, Law, and Ethics. Section 2 discusses privacy laws. This section focuses on the last two learning outcomes for the chapter, identify major national and international laws that relate to the practice of Infosec, discuss current laws, regulations, and relevant professional organizations. Many organizations collect our data, and we often give it willingly, free of charge, or at very low cost. We do look to the government to protect our privacy, but with few laws on the book, we must be personally vigilant with our own data and professionally vigilant with those whose sensitive data we oversee, like personally identifiable information related to healthcare. In healthcare and across industries, substantial gathering of data and translation into big data represents ethical challenges. Unethical or even unprepared organizations must protect the sensitive data that they control. When we define privacy in this context, it's not an absolute definition. Instead, it is freedom from unsanctioned intrusion. Information security professionals must carefully guard sensitive data based on legal and ethical obligations. In general, the courts in the U.S. attempt to balance the purpose or need for information about you with the reasonable expectations of privacy that you may have. As Ronald Reagan said, freedom is never more than one generation away from extinction. We didn't pass it to our children in the bloodstream. It must be fought for, protected, and handed on for them to do the same. Thus, we must continually strive to balance privacy with reasonable expectations of the government and the purpose of the use of the data. There are other ways that people infer privacy protection in the U.S. Keep in mind that privacy is never explicitly mentioned in the U.S. Constitution. Thus, every right to privacy has to be inferred from other guaranteed rights. One of those ways that privacy is inferred is the Bill of Rights, the 10 amendments that were ratified to protect the privacy of individuals, among other protections. Specifically, the Fourth Amendment, which states that the right of the people to be secure in their persons, houses, papers, and effects must not be violated unless a proper warrant has been issued, is the main way that people infer privacy. To be secure in my person, I can be in my house and is considered private. The right of privacy is one of the most sought after and valued rights in the U.S., the right to be left alone, the most comprehensive of rights and highly valued in the U.S. When you combine communications privacy and data privacy, you have information privacy. Communications privacy refers to your ability to communicate with others via phone, by text messages, through Skype, without having those communications monitored by others. However, when you communicate with a second person, you lose some of your privacy rights. It is not a secret if you tell someone else. Thus, you may not want, need, or realize you gave up privacy. Data privacy refers to your ability to limit others from accessing your personal data. You may decide to allow others to use your data, like having a Kroger card and allowing them to provide you with relevant coupons and discounts, but it's a conscious decision that you make. Unfortunately, many of us click on I agree and allow others to use our data in ways that we may not expect. Once you agree is covered under contract law and enforceable in most nations. We need to read what we're agreeing to do, but we rarely do. The Electronic Communications Privacy Act, ECPA, is a foundational law in protection of electronic information gathering. ECPA only applies to protecting communications while they are in transit from the sender to the receiver. Think about that. The only protection is given to that tiny amount of time when information is sent from one place to another. Think about a simple email message. How long is it in transit? That's the only time that ECPA provides broad protections. ECA does protect some communications held in digital form, but typically only data that the information owner has agreed to share and under the circumstances under which they agree to share their data. Information stored on a business, organization, or hospital server is generally not protected. Email messages written at work, not private. Email messages on your personal account while using the network at the hospital, not protected. Be careful what you send and receive, and vigorously protect the data that your organization owns. Finally, ECPA prohibits recording or otherwise capturing telecommunications information without a search warrant. You are not allowed to intercept cell phone messages even if you have the capability, which that capability exists. You should get rid of it if you inadvertently retrieve it. And you should report all violations immediately to reduce liability where possible. Take a look at these 2 YouTube videos to get more information regarding online privacy through the years and privacy laws in our digital era. Let's look at the Federal Privacy Act of 1974. This was landmark legislation and still provides foundational privacy protections today. This law regulates how, why, and under what circumstances the federal government is allowed to use private information. It further establishes a code of fair information practices that relate to how data is collected, maintained, and used, as well as how it is shared with other agencies, organizations, and/or the public. This act was created to make sure that government agencies protect the privacy of the information that they gather. Since the federal government is responsible when the information is released without protection, it's important that the data is safeguarded. Finally, the Act requires public notice of the records that are kept on you and allows you to make changes when data is inaccurate. The Federal Privacy Act of 1974, together with the Fourth Amendment to the U.S. Constitution, if you remember, that's freedom from unreasonable search and seizure, comprises most of the privacy protections that U.S. citizens expect and that are guaranteed by the law. However, huge amounts of data is collected on each and every person, and most of it is not collected and maintained by the federal government. Keep in mind, these laws typically apply only to the federal government or data that is shared, managed, organized by and for the federal government. That excludes large amounts of data. What about it? How is it protected? Health data also has special rules applied to it in addition to the rules that are applied to financial data for obvious reasons. We want to have our health data secure. There's no need for you to know what illnesses I might have, what medications I'm taking, if I'm terminally ill. Unless you have a need to know, I have the right to keep that information private. HIPAA is Health Insurance Portability and Accountability Act. One thing it does do in addition to that is allow you to continue your health insurance coverage as you leave a job or change jobs or leave the workforce, whatever it might be. There are numerous HIPAA privacy violations each year. Each violation is a separate fine for each record that is incorrectly given out to someone or someone takes it, whether you intended for the data to be released or not, whether you had a good data security plan in place or not, you're still fined. Most of the violations are still where data is physically stolen. Doctors' offices have a lot of paper in there. They have somebody gets into their computer system, all sorts of ways. But typically data is physically stolen is the main thing. Let's look more closely at some of the protections provided by HIPAA, which is also known as Kennedy-Caspom. First, HIPAA protects the confidentiality and security of healthcare data by requiring the use of standard methods of protection and by standardizing electronic data interchange, or EDI, between collectors of healthcare data. Organizations with access to healthcare data must have information security mechanisms in place to protect the information owned. Further, clearly outlined and publicly published policies and procedures must be in place for maintaining the confidentiality, availability, and integrity of the information gathered. We typically sign a privacy policy each year when we go to a doctor's office, for instance, or a clinic or a hospital or any other healthcare provider. HIPAA further requires organizations collecting healthcare data must assess and continuously improve the information security systems, policies, procedures in place in order to protect the information gathered. Finally, HIPAA provides guidelines for the use of electronic signatures based on security standards. As you know, HIPAA should not be taken lightly. It clearly provides a set of standards that healthcare organizations must undertake. If data is not protected and there is a breach, even if it's unintentional, the fines, bad publicity, and sanctions may be significant. The 5 fundamental security principles outlined by HIPAA include: consumers control the medical information they provide. If consumers choose to give wide latitude in the use and reporting of their medical data, it's fine to use it. Use of consumer-owned data should follow a clearly outlined information security plan. HIPAA sets boundaries on the use of health information. That personal, confidential data must be carefully safeguarded. As leaders of the information security management at a healthcare organization, that responsibility falls on you and other managers. Those who collect healthcare data are accountable for the privacy of information that is, private. If a customer opts not to share data with a parent, a spouse, a child, or a friend, you must ensure that the data is kept private and as intended by the customer or the patient. HIPAA recognizes that there is a balance between the greater good of society and the potential impact on an individual. As such, it tries to set standards on how and in which situations data may be shared across organizations and/or other individuals for societal needs and improvements. Last but certainly not least, HIPAA requires that health information must be kept secure. Foundational principle. HIPAA is a broad law that impacts numerous stewards of information assets. It must be closely followed for organizations who potentially gather any healthcare information about consumers. Now let's take a look at the American Recovery and Reinvestment Act of 2009. ARRA contains provisions for development and security of electronic records. It was designed to provide a boost during the economic crisis in the U.S. and assist in moving toward a more widespread digital information age. The Act was specifically focused on providing tax cuts and funding for federal grants, contracts, and loans in an effort to move more quickly toward electronic capture of paper healthcare records. Further, ARRA bans the sale of health information while promoting security and privacy of healthcare data. Patients are given specific rights to access and modify inaccurate records about them. HITECH was enacted as a part of the Act and in cooperation with existing HIPAA rules and regulations. HITECH further required entities covered under the law to notify information owners of breaches in their data. Prior to that there was no legal requirement for entities to notify patients and information owners that their data may have been compromised. That's actually an important change. Now we at least know if our healthcare data has been breached. The recent Blue Cross Blue Shield Anthem breach comes to mind, along with many retailers who shared information with customers that their data may have been accessed, including Target, Home Depot, TJX, and others. A breach is a significant black eye in the community for the organization, and you want to avoid it. Other laws have been passed which protect financial data. Healthcare organizations typically store financial and payment data along with healthcare data, so these rules are relevant to the information security managers at the organization. The two most relevant to healthcare are the Safeguards Rule, which requires documentation of a security plan, and the Pretexting Rule. Healthcare organizations are already required to document their safety and security plans through HIPAA, so the Safeguards Rule isn't a burdensome extra responsibility. It does, however, reinforce the importance of having an information security plan in place for financial and healthcare data. Pretexting is a relevant concern for healthcare InfoSec managers as well. With pretexting, people attempt to gather information that they don't have the right to access. They may call and pretend to be someone they are not. They may send an email and try to gather information that they are not entitled to, or they may call on the phone to try to do it. Information security managers must vigilantly guard the confidential customer and financial data that they gather and keep. Gramm-Leach-Bliley is also relevant to InfoSec managers in healthcare. It requires companies that offer financial products or services like loans, insurance, payment plans to explain how they gather, share, and safeguard sensitive data. Customers may make payment plans to their healthcare providers, organizations, hospitals, clinics, and those clinics may offer them payment plans or other financial opportunities as well. Along with the other laws we discussed, Gramm-Leach-Bliley increases the documentation requirements that companies must follow. The U.S. government has created additional laws that relate to export and espionage and that may be relevant to healthcare providers and those who collect, gather, store, and secure information assets. The Economic Espionage Act, or EEE, of 1996 protects intellectual property and the competitive advantages and trade secrets that you may have acquired. EEE applies to organizations and defines industrial espionage as the foreign government that uses its classic espionage apparatus to spy on a company. Think of the Sony hack a couple of years ago that was widely attributed to North Korea as a result of the movie that was released that was critical of North Korea. Industrial espionage is also defined as two American companies that are attempting to uncover each other's bid proposals. You could certainly see how that would be valuable information as healthcare providers are trying to gain the insurance for a state, for Georgia, for instance. They may want to know what others have bid on it to try to make their bid more appealing. It can apply as well to that disgruntled former employee who walks out of his former company with a computer diskette, as the law says, but I'm going to replace that a USB device. You plug it in, you get information that you either have access to and should not share, or that you don't have access to. Second, there is Security and Freedom Through Encryption Act of 97. It provides guidance on using encryption and protects some information from government intervention while reinforcing the individual's right to use or sell encryption algorithms or not. It also prohibits the federal government or agencies from requiring that those with whom they do business to use encryption. However, as an information security manager at a healthcare organization or an organization that gathers and stores healthcare data, my advice is to encrypt and secure the data you control with all methods available to you. We have mentioned intellectual property multiple times now. Let's look a little closer at copyright protections, which allows you to secure the data that you own, create, share, or access, and allows you to recoup research and development you may have undertaken. In the U.S., protection is offered to authors of original works of authorship, to include literary, dramatic, musical, artistic, and other intellectual property. Does it apply to databases of information that you gather? Maybe, if it's sufficiently creative. If it's just a complete database of every patient and outcome and other data, it may not be considered creative and thus may receive little or no protection, at least in the U.S. The EU has other rules on databases. If it's a database that brings together those who had high readmission rates, let's say, at the hospital and gathers data to examine root causes of readmissions, it might be considered sufficiently creative. Make sure the Infosec team is well versed in the legal and regulatory requirements and work closely with an appropriately trained legal team that has expertise with intellectual property. It's important to note that copyright protections are available whether you publish or don't publish a work, and whether you put a copyright symbol or not on it. If the person should have known this was a published document, you can still bring suit. However, to bring suit for infringement, you must register it with the Copyright Office. When we talk about copyright, it's important to understand that they only protect the expression of ideas, but not the ideas themselves. Society as a whole owns the ideas, while people decide how to express their vision of the concept. For instance, I cannot get a copyright for the idea of having a happy birthday, but I could create an original song that expresses my version of happy birthday and get a copyright for it. However, distinguishing between ideas and expressions is often difficult. It's not as easy as the happy birthday idea and the happy birthday song. We are encouraged to build upon the work of others, but we must use care to ensure that we're using our own way to express the idea. Copyright law does not allow for protection of concepts, facts of nature, math equations, or symbols, and so forth. You can't own the quadratic formula and charge a fee every time someone uses it. While the idea is not protected, the expression of that idea may be protected, even if the expression is not particularly creative, novel, or non-obvious. If a person seeks IP protection for product ideas, processes, or symbols, she or he must seek a patent instead of a copyright. Copyright does last for a limited period of time, and then it will enter the public domain. So the protection is not forever in most countries. A person who obtains a copy of a copyrighted work may sell or transfer that copy under the first sale doctrine. For instance, I can sell you my textbook if I bought a hard copy of it. However, I can't copy the textbook and give you or sell you those pages. It doesn't matter if you make a profit or not. There is the fair use doctrine that must be considered. This is particularly useful for educators, but it applies in other settings. For instance, for commentary, for discussion, like in the classroom, or in a newspaper, or for satire, you can always make a fair use of a copyrighted work. In general, you want to seek permission or give credit or whatever might be appropriate in your situation. Fair use is not absolute. Who decides if it's fair use? Well, of course, the jury or the reasonable judge or the reasonable jury of our peers. They may not be as reasonable as us, though. I encourage you to take a look at this YouTube video that does clearly describe how ideas and expressions are different. In the past, the important and profitable aspect of having exclusive rights through copyright was the ability to reproduce. You reproduced your book and sold it to people. You reproduced office CDs and sold copies to people. The internet has really changed the way that copy holders view their rights. It's the right to reproduce and share with fees or royalties or payments online. It's cheaper, more efficient, and easier for all involved to share online. It also allows the copyright holder a bit more ability to control who has a copy of a product and if their license is up to date. Further, students may purchase or rent an electronic copy of a textbook, usually, at significantly reduced cost. Copyright also gives the copyright holder the right to create derivative works, although it's not always easy to tell if it's derivative or a new way to express the same idea. Copyright holders have the right to perform the work publicly through singing or dancing or acting in a play, or demonstrating a new operation technique, to display publicly in any form deemed appropriate, and to perform the work digitally, for instance on YouTube, or by recording the song or music. Now we know about copyright. Where is your potential for the use of copyright as a suitable way to protect intellectual property? Copyright is a viable option to protect software and mobile applications. It's cheaper to obtain than other IP protections, and it provides longer protection, often life plus 70 years for the author. However, copyright only protects expressions of an idea. Patents, on the other hand, may protect entire systems. And while copyright only protects against direct copying and does not protect against independent creation, patents do. As an Infosec professional, you need to determine the best way to protect your information technology, patient, and practitioner-related intellectual property. As said previously, it's always a good idea to have a legal team with experience in intellectual property in the healthcare field. When someone accuses another of copyright infringement, the substantial similarity standard is often called into play. The copyright holder needs proof that the person copied the work in an illegal or improper manner. The product cannot be the result of two or more artists independently arriving at the same creation. That is, they expressed the ideas in the same or almost the same manner, but they independently came up with the expression. Copyright does not protect against independent creation of the same or even very similar manners of expressing ideas. When considering whether copyright infringement has taken place, the copyright holders or their legal teams try to evaluate if the person they believe infringed had access to the work in question prior to creating their own work. If the person had access plus a substantially similar expression of ideas, the courts consider the product or service to be copied, and copyright protections have been violated. For instance, if you come up with a first-person shooter game that looks remarkably similar to Call of Duty 4, and your brother played Call of Duty 4 and you likely saw it, then you can't claim you didn't have access. The only thing left is determining if it's substantially similar. Who can forget the absolutely iconic image of Barack Obama's Hope poster? The poster was created in a day by a street artist named Shepard Fairey. It was used in 2008 and in 2009 and ultimately made it to the Smithsonian. However, several groups came out and said that the photo was theirs. You can see the 6 photos that purported to be the basis for the Hope poster. In the last sequence of pictures, you see the AP photo by Manny Garcia from 2006 on the left, with a closer view in frame 2, and then the final image in frame 3. In the end, Shepard Fairey received a $25,000 fine and 2 months of probation, in part because he destroyed documents that showed he had seen the AP photo at some point prior to creating the image. Remember, substantial similarity plus access equals copying. He didn't want them to know that he did have access to the image in question. Have you read The Da Vinci Code by Dan Brown or seen the movie with Tom Hanks? Louis Perdue challenged that his earlier book, Daughter of God, was unfairly copied to make the Da Vinci Code. If you remember, the Da Vinci Code talked about various religious themes and historical legends that were common knowledge or ideas. While the two books were very similar, the courts decreed that the similarities were ideas. Since ideas cannot be protected, but only how the ideas are expressed, there was no case. As U.S. Judge George P. Daniels ruled in April 2006, a reasonable, average lay observer would not conclude that the Da Vinci Code is substantially similar to Daughter of God. So a reasonable person came back again, and we'll keep seeing this person who isn't always so reasonable, we could argue. Further, Judge Daniels said that any slightly similar elements are on the level of generalized or otherwise unprotectable ideas. In another high-profile case, Joe Satriani, do you know him? He accused these people, Coldplay, do you know them? Of copying some of his material in Viva La Vida, their world-famous song. The suit was dismissed from the court in 2009, although there were indications that a private settlement was reached. If you only watch one YouTube video in this class, take a look at this one, which overlays the music for you to see the similarities. It's only 1:50, and it's a worthwhile investment of 2 minutes of your life. Was there substantial similarity, which is access plus copying? I'll let you decide. Enjoy. From an information security perspective, this case and the others that we discuss reminds you that transformation of digital files or stuff must be significant, or you may be guilty of copyright infringement. Did you make modifications to your EPIC system? Where did you acquire the ability to make those changes? If it was done in-house, did you hire someone from a competitor who made similar changes? Were the changes you made significant enough that they would not be considered access plus substantial similarity, which equals copying? You may face legal and or financial liability if substantial similarity is proven. Make sure you determine the background skills and abilities of those you hire, and make sure that you are aware of covenants not to compete that they may have signed. Similarly, ask them to sign covenants to compete for you as well. Covenants not to compete. The Freedom of Information Act was passed in 1966. It's been around a while. It requires all federal agencies to disclose records requested in writing by any person. However, it only applies to federal agencies and does not give a right of access to records held by Congress, the courts, or by state or local government agencies. Therefore, your organization may or may not be affected by these guidelines. Each state has its own laws that should also be considered prior to gathering or sharing sensitive, personally identifiable information. The best way to ensure you're following all of these guidelines is to have access to a skilled legal group with expertise in the healthcare field. Incidentally, Georgia is a Freedom of Information state, so state employees should never send email messages that they don't want to see online or in the local or on the local news later that day. To summarize, the government attempts to create privacy laws to balance the individual's right to privacy with society's need to have access to information. And in the case of healthcare, for your providers and doctors and hospitals to access personal records while preserving the privacy rights you request. Laws are already too old by the time they hit the books. Legislators simply cannot move fast enough to catch up with changing technology and changing medical practices. As an information security professional, you own the information assets in a healthcare organization. As such, you have much higher standards as compared to those fields with less data and or less concerns about privacy rights. Clearly, healthcare information is personal and private and individually identifiable and must be protected. As an information security professional, you should follow the rules, regulations, and guidelines at the local, state, city, regional, national, international, if applicable, levels. You should be vigilant in protecting the information assets you own. If they're on your system, then you, or the organization, is responsible for keeping them safe. We continue Chapter 2, Compliance, Laws, and Ethics. Section 3 looks at SOX, breach laws, and international and state laws. This section will cover the last two learning outcomes for the chapter, identify major national and international laws that relate to the practice of information security, and discuss current laws, regulations, and relevant professional organizations. You may have heard of the Sarbanes-Oxley Act, or SOX, which was passed in 2002. SOX holds senior management accountable for the integrity of the organization's financial data and internal controls. CEOs and CFOs, for instance, may face up to 20 years in prison and high fines for falsely certifying corporate financial reports and reports on internal controls. Think about that. C-level employees can face jail time if financial data is inaccurate and/or internal controls to protect data are lacking. As an Infosec professional, you must do your part to ensure that proper controls are in place. SOX was created in response to several well-known scandals such as Enron. Enron was the impetus for some sort of action by Congress. Enron raided employee retirement accounts and, together with its auditor, Arthur Andersen, showed profits that were inaccurate. As they ran out of funds, senior executives began to sell their stock without telling anyone else, and then used retirement funds to bolster the company's image. Employees lost that money, and since there was nothing left to recover, they could not even sue for damages. Thousands of former workers, 60-something years old, lost everything. They were in retirement and had nothing left. The public was outraged, and Congress responded with SOX. Section 404 states that CEOs and CFOs and COOs and other C-level executives, in some cases, are liable for certifying that the reports presented are accurate. In response, most organizations design multi-level certification protocols where lower-level employees certify the information that they present. Their managers certify the information up the chain and all the way to the top. In that way, C-level executives insulate themselves against legal repercussions. Otherwise, they argue, they would have no way to know if the inventory figures for a particular quarter in a particular product or service were correct. Think about a large bureaucracy with multiple layers. Although the C-level executive is ultimately responsible for what is reported, there is no way that he or she will know the specifics about every aspect of the company. Thus, to date, few executives have been prosecuted under SOX. Section 406 requires that public companies must inform the public whether they had a code of ethics and if there are any waivers of the code. For instance, they may waive the code for their organizations operating in countries where bribery is common. You still must follow U.S. law. Waiving the code for any portion of the organization is asking for legal trouble and closer scrutiny. Still, the chances of being prosecuted under SOX have to date been very slim. If you get a chance, take a look at some of the details about the Enron case as shown in this YouTube video. Or you can watch the made-for-TV movie, The Smartest Guys in the Room. Let's take a closer look at Code of Ethics requirements for SOX. The code must apply to all employees equally, including senior managers who can't sell their stock while the company goes under, the board of directors, C-level employees, and rank-and-file employees. If different standards are used for different levels of the organization, people will likely be suspect of the resulting code. If the top leadership does not adhere to the code, it is unlikely that others will display the ethical behaviors that are desired. If employees are excluded from development of the code, it is unlikely they will understand and follow the code. Buy-in of the Code of Ethics by all employees is needed at all levels. The code must also be known by employees who receive regular training. We already do that, we know that. as well as being accessible to shareholders, business partners, and the public. Codes of ethics must be consistently applied to the organization's decision-making and be implemented into the culture of the company. Everyone is treated the same and should make ethical choices based on the same code. Let's take a look at the Digital Millennium Copyright Act, which attempted to update laws and reduce copyright infringement. It was a U.S.-led effort to minimize theft of intellectual property and ensure privacy of individual information assets. DMCA primarily focused on outlawing equipment that deliberately bypassed copyright protections, thus violating intellectual property laws. Similarly, the EU created a directive that increases individual rights to process and freely move their own personal data. The EU generally has more stringent privacy policies than the U.S. In fact, if U.S. companies plan to move globally, information security professionals must be aware of and respond to the differences in legal and ethical manners. The UK itself implemented a version of DMCA called the database right. Other countries, including Australia and parts of Asia and South America, have implemented or are considering implementation of similar regulations. There are local, state, regional, and international rules regarding how to respond to breaches. In addition, some industries have set up their own guidelines for responding when data is potentially compromised. Breach laws typically require that the company who experienced the breach must provide support to those whose data was compromised. This support may include free or discounted credit monitoring, along with a description of what the company has done since the breach to reduce the chances of it happening again. Think of the recent Experian breach as an example. They offered free protection for a year and the ability to freeze access to your financial data for a year. However, it is unknown if they will extend these free options after 1 year. The U.S. does not currently have a national breach law, although several are pending. Some states have passed laws regarding breaches, and most companies will alert their customers when a breach has occurred. If they don't, sometimes information security researchers will learn on their own about the breach and pass it along to others through various sources. In the long run, companies should have a crisis response plan with a team of employees from human resources, public relations, operations, computer science, accounting, management, finance, etc., with different roles to take when, not if, a breach occurs. Let's now look at PCI DSS, which refers to Payment Card Industry Standard. It is a set of industry guidelines or standards that must be followed by organizations that handle credit and debit cards. PCI DSS is an effort to reduce the impact of the very expensive credit card fraud. The current standard, which is 3.1, focuses on 12 requirements in 6 areas, as discussed on the next 2 slides. The first 2 requirements refer to securing the network, developing systems, and maintenance. They include installing a firewall. Does anybody not have a firewall now? As well as protecting cardholder data. Second, modifying default systems passwords. Don't leave them the same if they're similar across other technology purchased by others, and configurations on a regular basis as required. The next 2 requirements deal with cardholder data protection, including general protection of stored data, as well as using encryption when sending data on open public networks. Requirements 5 and 6 deal with vulnerability management program maintenance. In other words, are you prepared and do you take regular precautions to handle threats? using properly maintained and routinely updated malware and antivirus protection, along with securing systems and maintaining updates for applications, are the main components of this section. Looking at requirements 7, 8, and 9, they refer to ensuring implementation of strong access control measures. These requirements include using need-to-know access controls to make sure that only those users who need access have access. Further, including formal access control mechanisms for the network to carefully identify and authenticate users is essential, as is managing physical security for information systems. The final category is network monitoring and testing, which makes sure that organizations routinely monitor who accesses data, have a log to track those who access assets, and a clear audit trail to follow if needed. For this category, organizations must periodically test security systems and processes. Companies who follow these guidelines minimize their risk of a data breach and may reduce the penalty if, or shall we say when, a breach occurs. The benefits of using PCI DSS include increased customer trust due to belief in the security of credit and debit cards. If you don't hear about a breach with your credit card company, you generally feel pretty secure. Improved reputation. You don't want others to hear about your inability to secure the information assets you own. Prevention of security breaches due to the measures put in place in line with PCI DSS guidelines. Following the guidelines themselves causes you to think through the processes used to store and retrieve information assets. Assistance in complying with other security standards, both current standards and those in the future. If you follow PCI DSS, they will give you helpful hints on how to implement with relevant HIPAA laws, portions of the Patriot Act, etc. You will be part of a community that is concerned with securing the information assets of the organization. Support for organizational strategies to continuously improve the security of information assets. You will receive helpful advice on how you can plan for the future and what threats you need to know about. Finally, increased efficiency of underlying infrastructure due to better planning and routine process for standardizing maintenance of technology components. Follow the process and you'll have well-maintained technology, updated software, and you won't have technological obsolescence, which causes its own problems. While it's hard to wade through and understand U.S. laws, adding global laws to the mix makes it even more challenging. Many of the laws in the U.S. do not apply to international trade, have no equivalent internationally, and may be regulated by treaties, trade agreements, and other regulatory bodies. Some countries have unstable and complex, ever-changing governance structures, and as such, they may have unreliable infrastructure, constantly changing leaders, and very different rules on privacy and information security. There are few international laws related to privacy and information security, although there are treaties which regulate how member nations are treated. Keep in mind that even with laws on the books, enforcement of laws varies widely from one country to the next. It may surprise you that India and China have very similar intellectual property protection laws as the U.S., particularly regarding copyright, but enforcement is very different and cultural views are dissimilar. When you start looking at international ethics of IT organizations, it gets murky. As we have discussed, international guidelines and laws vary, and sometimes bribes are necessary to work within a country. Get lawyers involved, ones who are familiar with international law, and follow the organizational code of ethics as closely as possible. Global firms must be aware of and respond to policies around the world. For instance, Intel, among many others, has faced charges in the EU, Japan, and South Korea. Qualcomm received an over $200 million fine by the South Korean Fair Trade Commission several years ago, and the epic Apple and Samsung battles continue in U.S. and South Korean courts, which have reached very different conclusions at times. Taking a look at several laws with a global component. Each of these laws listed, you have different participating nations and different standards of enforcement. We've mentioned DMCA, and then you've got some other acts here that are like the general agreements on tariffs and trades. When you have multilateral agreement, it's easier for you as an organization to work because it's not just you and you have to make an agreement with each country. TRIPS is one group that regulates intellectual property rules across the world. While it states that all classes of inventions, with the exception of certain life forms, are eligible for patent protection, it is silent on intellectual property protections for software. The nations who are TRIP members are shown in dark green. The Patent Cooperation Treaty provides some protections for intellectual property related to patents and has a substantial number of members with 148 participating countries. World International Property Organization, or WIPO, has 188 member states through which it guarantees patent protections. As you can see, though, these are all different countries depending on the different rules. The Berne Convention allows or requires partner nations, 168 signatories as highlighted in dark blue, to receive national treatment. That does not mean that you will receive good treatment or similar treatment to what you would receive in the U.S. It means when working in another country, you will receive the same treatment as other citizens receive in that country. The length of copyright protection also varies, as shown on this map. The Paris Convention has 176 signatories that follow the guidelines of its trademark agreements. Like the patent agreement we discussed earlier, the Paris Convention extends national treatment, not good or bad, just national treatment to trademarks of its member nations. The Madrid Protocol provides guidelines on trademarks across the world. It has 176 signatories and includes procedural and administrative protections in line with the rules and regulations that apply to citizens of the country, much like national treatment. Countries often run into unanticipated intellectual property problems when they decide to expand globally. Let's take a look at China and Microsoft's adventures as it tried to launch Xbox consoles there. After almost a decade of making them illegally, China finally allowed makers of video consoles to sell products in its country, provided they partnered with a Chinese firm. Microsoft struck first, partnering with Best TV in 2013. However, the Chinese government said that they were collaborating to strategically dominate the market with official hardware, which was counter to antitrust rules in China. The main problem here was that they failed to notify the Chinese government as required by law. In 2013, both companies were fined just over $30,000. At the time, Microsoft was also under investigation for antitrust violations with its Windows and Office products, so they delayed the launch of Xbox One in China. They later formed a legal cooperative agreement with Best TV. Sony initiated an agreement with Best TV as well, seeking to sell their PS4 console in 2017. The Chinese market for video consoles is unique in that most young people currently play games on PCs or mobile devices. It will be interesting to see where the video console market goes in China. Obviously, if you're Microsoft and Sony, you hope to sell your products to the large Chinese marketplace. This marketplace would also be ripe for healthcare applications that might be relevant, particularly to people in rural areas of China who may benefit from telemedicine, for instance. From 2012 to 2015, the EU Commission was concerned about Amazon, its ebook business, and whether it was anti-competitive. They launched a full investigation in June 2015. Commissioner Margrethe Vestager, in charge of competition policy, said Amazon used certain clauses in its agreements with publishers which may have made it more difficult for other ebook platforms to innovate and compete effectively with Amazon. We want to ensure fair competition in Europe's ebook market worth more than €1 billion. They were quick to point out that they were not trying to penalize Amazon for being successful in gaining market share that way. The clauses in question required publishers to let Amazon know when they gave more favorable or different terms to competitors of Amazon. Amazon does this to ensure that they receive as good or better clauses as their competitors. In 2017, in an agreement with the EU, Amazon agreed not to include these clauses in agreements with publishers and not to enforce agreements that had already been negotiated, allowing them to freely compete in the large and wealthy EU market. Let's take a look at Google and lawsuits in the EU and Russia. First, let's talk a little about Google. It's my search engine of choice. I could not live without Google, I don't think. I use it multiple times per day for research, for general how-to help, for direction, for shopping hours, to determine if I have a brain tumor, whatever it might be. It's an essential part of my life. That's not necessarily true elsewhere. If we start with Russia, Google had a lawsuit there that they lost. Now it's required to let users choose their default search engine. In 2017, Google was fined $2.7 billion by the EU for manipulating shopping results and moving competitors down. The EU found these practices violated EU law and awarded the largest fine in EU history. Google is currently appealing as of late 2017, and if they win the appeal, they will be able to continue the practice of moving competitors up. While appealing, they have had to change the way their searches rank results in the EU, but hope to be able to change it back if they win on appeal. In 2015, UK-based Street Map sued Google, alleging that its mapping services violated anti-competition rules. The courts ruled in Google's favor in that case, finding that the mapping services did not significantly affect competition. The $2.7 billion EU award against Google could be a sign of things to come. If others find that Google abused its marketing position, then they face similar lawsuits. The EU ruled that Google, quote, abused its market dominance as a search engine to promote its own comparison shopping service in search results, end quote. Expect more lawsuits to come. When you're large and successful, people are always watching to ensure that competition is alive and well. We will see what the future holds for Google and lawsuits internationally. Yahoo also faced problems in the global environment. It was selling Nazi paraphernalia, which is a violation of French law, but is not a violation of U.S. law. Yahoo France had no links to Nazi materials on its France website, but did have links on its U.S. website, which French citizens could choose to access. France said that Yahoo had to do better than that and keep the material out of the reach of French citizens on any servers. The California District Court disagreed, saying that it was a violation of U.S. free speech to censor Nazi materials. France appealed, and the case went to the Ninth Circuit Court of Appeals. They reversed the district judge's order on a technicality, saying that it was likely that California did not have jurisdiction over the issue. It was also unclear to the Court of Appeals whether Yahoo needed to do anything else to comply with the French order, or if those actions might violate U.S. freedom of speech protections. France appealed, but the Supreme Court refused to hear the case. They first agreed that France could not force Yahoo to remove the links, but then two appeals courts ruled that they did not have jurisdiction to hear the case. Some of the justices argued that the U.S. would only have jurisdiction if France tried to enforce its court order on U.S. soil. It is imperative for Infosec professionals to understand state laws and regulations that apply to their organization and industry. State laws differ significantly from state to state. The Georgia Computer Systems Protection Act sets up several computer security provisions and gives penalties for the use of technology to attack or exploit information systems in the organizations. The Georgia Identity Theft Law requires that a business may not discard a record containing personal information unless it further shreds, erases, modifies, or makes the information unable to be retrieved. Again, Georgia laws are just that, valid in Georgia. They are enforceable across state lines as long as they don't conflict with the other state's laws and as long as they don't conflict with federal laws. You've heard the saying, ignorance of the law is not an excuse, and that's just as true in the information security, healthcare, any field you're in. That's why Infosec professionals must continuously update themselves on changing rules, regulations, and law. However, what if an employee says they didn't know because there wasn't a policy, or they hadn't been educated on the policy? Well, okay, that's a much more reasonable argument. As an information security professional, however, you have to get beyond that argument. You have to make sure that policies are distributed to individuals who are expected to comply with them, readily available for employee reference upon request or as needed, easily understood with translations needed for diverse groups within the organization, acknowledged by the employee, although that's usually through a signed contract, often completed within the first week of employment in the other stack of papers that you go through. But since we don't remember that sheet of paper 5 years later, we need the policy to be uniformly enforced and reinforced through regular security, education, training, and awareness efforts, and enforced for all employees from the CEO down. To summarize, Infosec professionals have a responsibility to be aware of all relevant laws, rules, and regulations from local, state, regional, and national levels to the international level for global companies. It sounds daunting, and it is. Often, attorneys with experience in the field can provide much needed legal advice. This is particularly true for the international arena. Infosec professionals must make sure that policies are clear, distributed, and made available to all in an understandable format, reinforced periodically through security education, training, and awareness, and enforced consistently across all levels of employees. Proper use of Infosec policies and controls may limit liability and reduce potential penalties. We continue Chapter 2, Compliance, Law, and Ethics. Section 4, Ethics in information security. In this section, we will focus on the first two learning outcomes for the chapter, differentiate between law and ethics, and describe the ethical foundations and approaches that underlie modern codes of ethics. Let's start by asking, why do we need to know? Why do we care? Of course, you need to understand these concepts to do well on the course, but beyond that, and hopefully well beyond that, if you understand legal and ethical concepts, you will be better prepared to talk with other professionals. In particular, think about talking with consultants that you hire to help you improve your business. The more informed you are, the better you will be able to make the decisions that are best for your organization. In addition, you need to understand issues related to ethical use of technology both in the U.S. and globally. In our increasingly complex global society, knowledge of these issues is essential. However, you should always consult with a global attorney who is familiar with the local customs and laws in the countries where you plan to operate. This class will absolutely not teach you to be a lawyer, but it will teach you to be aware of and understand legal and ethical technology issues that may affect you and your organization. Now let's move to defining ethics. How would you define ethics? Do you know what ethics means? We all likely follow ethical standards in our personal and professional lives, but we still have different definitions of ethics. From businessdictionary.com, ethics is defined as the basic concepts and fundamental principles of decent human conduct. We all know what decent human conduct means, don't we? We likely may disagree about exactly what constitutes decent, and frankly, we are all correct in our assumptions. We develop ethical values based on nature and nurture characteristics, and we all grow up in inherently different homes with different religions, customs, and family history. Values that are considered when looking at ethics include equality of all men and women and basic or essential human rights that apply to everyone, regardless of any individually identifiable characteristic, including things such as race, ethnicity, country of origin, gender, and so on. Ethics also includes obeying the law of the land and being concerned for health, safety, and recently added to the discussion, concern for the natural environment. If we look, though, at its most basic conceptual level, ethics refers to what is right and wrong. We follow social norms when we behave ethically, but again, our ethical beliefs may vary depending on our groups, or what I call our tribes. We have many tribes that we belong to. I am a wife and mother and have a family tribe that goes along with that. I am a professor and have colleagues that are part of that tribe. I have friends that form a tribe or group. I am a woman, which is another tribe, and the list goes on and on. We all belong to different tribes and are influenced by all of them, and interestingly enough, there's a lot of overlap between many of our tribes with people we wouldn't think were part of our groups. Our families and upbringing influence our beliefs about right and wrong, and so does the education we receive, the friends we have, the church we attend, the games we play, the people we date, etc. We all are in many different groups or tribes, and each tribe may have different sets of ethical standards. Correspondingly, our ethical behavior generally follows accepted social norms of the group, or what I call tribe, that we belong to. Of course, doing what is ethical is often hard. Do you turn in your friend if she or he cheats? How about your significant other? What if it's your mom? I have some students that say I'd turn her in. Others squirm at the possibility of even turning in a student they don't know. Our ethical standards may allow us to turn in another student for cheating, but we may balk when we consider turning in a close relative, friend, significant other. We consider the standards of the group or tribe that we are part of when we ethically evaluate particular situations. And it's hard to make consistently fair and ethical decisions when we are placed in tough situations. You can take an entire semester and write a thesis on how to resolve ethical dilemmas. In this class, however, we will touch on 4 approaches to responding to ethical dilemmas. You can read more about some of these approaches in the textbook. First is the virtue approach. With this approach, you consider your personal values and the values of your community to help in resolving ethical dilemmas. The virtue approach refers to traits such as honesty, kindness, patience, compassion, diligence, loyalty, fairness, and tolerance. With this approach, you ask yourself if what you plan to do reflects the kind of person you strive to be. Will it reflect positively on your company if it shows up on the front page of USA Today? Are you able to live with the outcome of the situation if it doesn't go as planned? With this approach, you're doing the right thing based on personal and other values. With the virtue approach, you try to do the right thing with the right person or people, to the right extent, at the right time, and in the right way. Although this is the objective, Aristotle considers achieving this goodness as rare, quote, rare, laudable, and noble, unquote. It's more important that we strive for virtue while realizing that it's hard to truly be virtuous across multiple situations and across multiple tribes. Another approach to resolving ethical dilemmas is the utilitarian approach. With this theory, you look at the situation and see which options produce the most benefit and the least harm. Thus, you evaluate the possible action based on consequences. What are the net benefits and costs to all stakeholders at the individual level? What is the least expensive option in terms of physical and non-physical potential harms or potential data compromise? Third is the fairness approach. This approach treats similar people in similar ways and only treats people unequally when they have differences that are relevant. For instance, someone with less experience in education may receive less pay than their more experienced and better educated managers. The fairness approach attempts to distribute good and harm in fair and equitable manners without discriminating unless there's a clear reason to treat different people in different ways. Thus, while direct reports may receive less than their experienced, well-educated employees, the differences in pay should be reasonable. Defining reasonable is one of the issues with this approach. We have mentioned the reasonable person standard, which comes into play in most of these ethical theories. Finally, there is the common good approach. Here you look at what would advance your group or your tribe the most. The common good approach looks at ethical solutions that will help our organization make money, distribute health care, educate the public, support a political candidate, etc. As a member of a community or tribe, you pursue goals that are common and beneficial to your community within the framework of an ethical decision-making strategy. You answer, what kind of community do you want to become, and how will you achieve organizational goals within this framework? All ethical decision-making strategies have limitations, and it's important to think about these issues as we make our ethical decisions. The value ethics approach does not provide a specific action plan to guide your actions. Further, virtue is difficult to define and depends on the situation that you encounter. How do we objectively define values? The utilitarian approach encourages you to produce the greatest benefit with the least harm. In practicality, it's often difficult to estimate and compare the benefits and cost of a specific situation. How much does it cost if you decide to pursue an IT outsourcing project to India versus China versus Mexico versus rural sourcing in the U.S. versus in-house? Some of these costs and benefits are difficult to estimate. How much customer goodwill is lost, for instance, if you move production to Canada versus staying in the U.S. versus moving elsewhere? Similarly, how much will it cost to partner with someone in another country who perhaps does not speak your language or know your customs? The fairness approach also has limitations. No matter our situation, we all bring personal biases with us. We develop biases early in life, and they are reinforced over time by our tribes. It's difficult to determine your own biases, and you cannot remove your bias from the situation. You attempt to recognize it and overcome it, but it's not an easy process. When you do make a decision, other flawed and biased people, just like you, may think you acted unfairly. With the common good approach, it is sometimes hard to reach a consensus on the best option available. Some may believe that a certain budget should be spent on IT infrastructure to bolster your company's scalability, while others may believe that investing in new mobile technology offers the best use of limited resources. Reaching a consensus between groups with different goals and different ways of solving ethical dilemmas, your different tribes, such as they are, may be difficult. And once a decision is made, one group often pays a higher cost than others. You do the best you can given your personal situation and the goals of your tribe. Ethical decision making is one tool that helps you decide how to proceed given uncertain situations. Let's look at 10 Commandments of Computer Ethics. You may have heard about this through another text that you've read or you've heard about, and these are 10 Commandments of Computer Ethics as stated by Computer Ethics Institute. Thou shalt not use a computer to harm other people. Don't steal someone's money or their identity or install malware that slows down their performance. Thou shalt not interfere with other people's computer work. If you stay out of locations where you should not be anyway, this isn't an issue. Thou shalt not snoop around in other people's computer files, even if it's your significant other, or your friend, or your boss, or your sister or brother. Access only what you are allowed to access. Thou shalt not use a computer to steal. See back at rule number 1. Thou shalt not use a computer to bear false witness. Don't tell lies online or in person about people. Thou shalt not copy or use proprietary software for which you have not paid. Do you have that friend who may have downloaded a song or a movie without proper permissions? We know we shouldn't do that. We know our friends shouldn't do that, but we still do occasionally. We shouldn't do that. Thou shalt not use other people's computer resources without authorization or proper compensation. Even if you only use a little bit of their bandwidth, it's not yours to use. Thou shalt not appropriate other people's intellectual output. If you didn't create it, it's not yours. You must properly credit the owner of the intellectual property and sometimes compensate them or pay to license the material. Or they may simply decide they won't allow you to use it, and then you can't use it. The last 2 commandments state that thou shalt think about the social consequences of the program you are designing. Don't release healthcare-related equipment, programs, mobile apps, etc. until they have been fully tested under normal conditions and you are very confident they won't cause any harm. And finally, thou shalt always use a computer in considerate and respectful ways. If you wouldn't like for someone to use your computer in the way you plan to use theirs, rethink it. This is similar to the golden rule: do unto others as you would have them do unto you. It's clear that security education, training, and awareness is part of the Infosec Professionals set of tools, set of requirements. In fact, when research looked at what is the major factor in changing ethical perceptions, particularly of small-scale groups as opposed to countries or states even, they found the answer was education. Security education, training, and awareness has to be considered a regular part of Infosec education. You can't just tell users once or twice, tell them regularly and give them real-world examples of ethical dilemmas they may encounter. So the Infosec professional can improve organizational ethics by offering training. We already know that. What outcome can be expected from the security education, training, and awareness? Well, you end up with a group of informed, well-prepared, and low-risk users. That's what organizations and InfoSec managers like to see. Let's look at why employees behave badly, the same reason people do anything they shouldn't do, and in unethical manners. We're going to look at three main reasons, and that's ignorance, accident, and intent. For those who are ignorant, security, education, training, and awareness that we're already going to do can help. Clear, well-written, consistently enforced policies are important. Make sure that all employees are not ignorant of the law or of your policies and procedures. When users accidentally make changes, they may cause great damage. Again, education can help, as can putting controls on those who have the highest level of access. If they make a mistake, it can be more catastrophic than a user with few permissions and little access. Then you have employees who intended to do something bad. They may be engaged in criminal or unethical behavior. The best plan is to find those users through controls that you have in place and to get rid of them as quickly as possible. Often, internal employees are the most dangerous. Rather than catch users as they unintentionally or intentionally make a mistake or do something on purpose, deterrence is a much better course of action. Laws, policies, and technical controls all deter unethical and illegal behavior. But it's not just having laws and policies, but having associated penalties and associated rewards. Make it known that violators will be punished. There is a probability greater than 0 that they will be caught, and appropriate penalties will be administered if an infraction occurs. Having positive rewards for those who do attend training, adopt ethical practices, notify InfoSec management when security problems arise, and generally stay informed about ethical and legal actions is also needed. It's the carrot and the stick that reinforces the desired behavior. To summarize, organizations operate under rules, regulations, and laws. These rules may vary based on state, region, and country, as well as the industry in which you operate. Healthcare organizations in particular have high standards to follow. Local, state, and national rules are all relevant, and international laws are relevant for organizations in the global economy. Ignorance of the law is already a well-known excuse. By reinforcing and educating ethical expectations, InfoSec professionals can make ignorance of policies a non-factor in ethical behavior. Security, education, training, and awareness offers an answer to many problems faced by InfoSec professionals. Enforce penalties to deter unethical behavior, as well as known rewards for behaving ethically, should be visible in the organization and reflected in annual reviews. We finish up Chapter 2, Compliance, Law, and Ethics, with Section 5 of 5, Codes of Ethics and Key Law Enforcement Agencies. In this section, we will cover the fourth learning outcome, discuss current laws, regulations, and relevant professional organizations. In addition to personal and professional codes of ethics, many organizations publish and adhere to their own codes of ethics. Codes of ethics define what the organization hopes to become or their vision for the future. You may talk about sister organizations that are similar to you, or aspirational organizations that you hope to be at their level one day. Codes of ethics specify the rules and regulations that members of the organization must follow, and also a commitment to professional development. In IT, this professional development is essential, or you'll be a COBOL programmer in a C# world. Codes of ethics do have positive incomes for you, the professional, and society as a whole. The codes outline how you will make decisions and how you will behave in ethically challenging situations. When an organization adheres to its own codes of ethics, for instance, when a product is recalled at no charge to the customer, the public may have a positive perception of the company, even if the product had to be returned for a full refund, of course, or even if people may have been injured. Finally, establishing, following, and reflecting upon the organization's code of ethics gives a starting point or a benchmark when you want to see how you're doing. It's like KSU having sister schools and aspirational schools. Sister schools define who we are now, but aspirational schools define where we want to be in the future. Within the IS field, there are numerous groups that claim to speak for the profession as a whole. ACM is probably the most well-known group and probably the oldest too, but its code of ethics isn't necessarily better than ISSA or others. Regardless of the organization, a code of ethics lets people know what's important to your group of members, another tribe, the core values that everyone has to follow if they are members of the group, or tribe, as I refer to it. Sometimes organizations look to professional organizations to help them create their codes of ethics. Most codes will say that an IT professional should contribute to society, avoid harming others, be honest, be fair, and don't discriminate, honor intellectual property rights, including patents and trade secrets, give proper credit to ideas taken from others, respect customer, employee, and employer privacy, and keep information confidential when you say you will do that. Virtually all codes of ethics adhere to these guidelines, and some go farther, specifically noting what you can and cannot do. These codes of ethics also flow naturally from the 10 Commandments of computer ethics that we looked at earlier. Organizations are generally risk-averse, with the exception of some startups and industries that thrive in that type of environment. Most organizations, however, try to limit financial and legal liability. Issues that contribute to increased financial and legal liability include lack of support for strong ethical conduct, lack of encouragement for ethical conduct, lack of ethical behavior by the organization, and lack of ethical behavior by all levels of employees. You don't have to take on information security all on your own, though. You have resources. You can use the organizations we mentioned previously or partner with agencies with similar goals at the local, federal, state, international arenas. You may also choose to partner with relevant law enforcement agencies. The FBI is one agency that promotes and tracks ethical behavior. They also seek to partner with U.S. companies to improve their information security efforts. The FBI introduced the InfoGuard program, which promotes efforts to educate, train, inform, and involve the business and public sector in information security. By involving diverse groups, the FBI hopes that U.S. infrastructure remains safe and secure, and that U.S. organizations have the most updated information to respond to potential international or national threats on their information assets. Every FBI field office has established an InfoGuard chapter and collaborates with public and private organizations and the academic community to share information about the current state of information security in the U.S. InfoGuard's dominant contribution is the free exchange of information to and from the private sector in the subject areas of threats and attacks on information resources. Companies should liaise with and establish partnerships with the FBI to remain on the cutting edge of information security. The National Security Agency, NSA, is the nation's utmost authority on cryptology. They protect U.S. information systems, infrastructures, and important industries, and produce foreign intelligence information where warranted. They are also responsible for signal intelligence and information systems security. The NSA's Information Assurance Directorate, IAAD, provides information security solutions, including the technologies, specifications and criteria, products, product configurations, tools, standards, operational doctrine, and support activities needed to implement the protection, detection, and reporting in response to elements of cyber defense. Thus, the NSA is another partner that may be secured in the fight against security breaches. The U.S. Secret Service, most well known for protecting the President and other politicians, serves as a partner in information security efforts as well. They were previously housed in the Department of the Treasury. They detect and arrest anyone committing a U.S. federal offense related to computer fraud or false identification, and now they are housed within Homeland Security. And they are an excellent source for Infosec professionals. To summarize, Infosec professionals can minimize liability with a clearly stated organizational code of ethics. Education, training, and awareness programs for information security should be used to reinforce important concepts. Law enforcement agencies at the federal, local, and state levels coordinate with organizations to reduce InfoSec crime and in form of malware, viruses, patches, etc. It's best to consult with attorneys who are well versed in your industry and location. This is particularly true outside of the U.S. There are clearly steps that InfoSec professionals can take to reduce organizational liability, improve protection of information assets, and comply with rules, regulations, and laws. Taking these steps in advance can reduce legal and financial liability and lead to a more aware, better trained workforce that delivers superior results.